Friends, I don't want to sound overly dramatic, but we're on the cusp of losing any semblance of representative self-government in the state of Tennessee if actions that were taken today, which is Tuesday, the 9th, by the House Civil Justice Subcommittee are not set aside. This is a critically vital issue. Now let me tell you what happened and why your ability to be represented in the making of the laws is at risk. Representative Rudd filed House Resolution 23. It would set up a committee of the House. It urges the Senate to set up a similar committee by which those members appointed to the committee would evaluate a decision by Chancellor Lyle of Davidson County regarding the absentee ballot laws that was issued prior to and affecting the August primary last year. 60-something, maybe 64 members of the House of Representatives are co-sponsors of that resolution. Now let me tell you what Chancellor Lyle did. No, I'm not going to tell you that yet. Let me explain what happened today. Representative Rudd goes into the committee and he says, Mr. Chairman, the chairman of the full committee, this is the subcommittee, is not available today. He's out. And my expert witness, which is going to be me, is also not available today because of a medical situation. And I would like to roll this bill 2 weeks so that I can bring my expert witness. And the members of the committee said, well, there are other witnesses here to testify against it, and they've come today, so we're going to go ahead and hear their testimony. That's fine. We do that all the time. And after that testimony, though, was over, somebody moved the previous question, which is non-debatable, and then they voted on a voice vote to kill the resolution, disregarding the fact that Representative Rudd hadn't been able to bring his witness to counter the testimony of the others and his request to roll the bill to do so. A resolution co-sponsored by 64 members of the legislature. Now, this can be fixed if the leadership and the caucus will insist that we're not going to do this to our members, that we're not going to allow them to have their bills killed on voice votes when they've asked to roll the bill because their expert witness is not there. They can make a motion to reconsider. They can make it clear they expect that motion to prevail. They can allow Representative Rudd to come back. I can testify. And then if they want to, they can do the same thing. Kill it. But now, let me tell you a couple of things you're going to liable to hear from somebody. Because I knew the day before I was not going to be able to testify today, I recorded a video 3 minutes in length, which is all the time I was given to testify, and I said, could it be played before the committee? The chairman said, no, but you can send the video to all the members. So some might tell you, well, we heard Mr. Fowler's testimony, but here's the difference between playing a video and being live. When I testify, a member of the committee could say, wait a minute, Mr. Fowler, what you just said, explain that again to me. Or wait a minute, wait a minute, the other side said this, and how would you answer that point? Well, see, all that's lost. All that opportunity is lost. To cross-examine me, for me to, in essence, cross-examine the other witnesses, all that was lost. Now, here's what's so fundamental about representative government. It's not just that the committee decided to kill the resolution. Committees kill things all the time. It's not just that the committee said we're really not interested in hearing experts from the other side. That can happen all the time. Here's the problem. Chancellor Lyle decided that fear of catching COVID should be a new reason for voting absentee. The legislature never had anything in there, never said anything about even being afraid of catching a disease. But Chancellor Lyle thought that needed to be an exemption for this period of time of COVID, that you can vote if you're afraid you're going to get COVID if you show up at the ballot box. Now, I think that decision is wrong. But you know, that's what she decided, and she can certainly apply that to the plaintiffs that were in front of her who asked for that relief. But that's not all the chancellor did. You see, the nature of the judicial power is that judges only resolve disputes between particular parties. And the judge can only grant relief to the plaintiffs that she has jurisdiction over. If she doesn't have jurisdiction over you, she can't speak to it. It'd be like her walking into my home and saying, David, this is how you should treat your wife or treat your children or whatever. It's like you don't have any jurisdiction inside my home over that issue. So you have to be a plaintiff to get relief. Well, she extended the relief she gave to those handful of plaintiffs to every voter in the state of Tennessee. She didn't have jurisdiction over every voter in the state of Tennessee. Her power can't go to that. For her to think that her power could extend to every voter in the state of Tennessee tells me something's fundamentally wrong with her understanding of the limited nature of the judicial power. Well, if I'd been a plaintiff, I might have been arguing, I don't want fear of diseases to be in the policy. The next thing you know, we're going to have somebody's fear of other diseases, and everybody's going to say, well, I'm afraid I'm going to get sick. I mean, you can't do that. Those plaintiffs didn't represent me. They didn't represent other people. They couldn't have represented everybody. And yet she made a rule that affected everybody. That is the equivalent of making a law, and that is an unrepresentative law. I'm going to rely on what Abraham Lincoln, a lawyer, said in the context of the Dred Scott decision that I think is so important. He said it about the United States Supreme Court and their decisions, but the same can apply to every judge who decides that he or she has jurisdiction to order relief in favor of parties who are not before the court. And it is this. He said, I do not forget the position assumed by some that constitutional questions are to be decided by the Supreme Court. Well, of course they are, if they're legitimately before the court, just as they were before Chancellor Law. I have no problem with her saying, I have jurisdiction, I have to make a decision. Great, fine. But then he said this, nor do I deny that such decisions must be binding in any case upon the parties to a suit. To a suit. Do you see the point? I was not a party to that suit. Were you a party to that suit? Was your voice being represented in that suit by the plaintiffs and what they were arguing? I doubt it. No, you weren't. Of course you weren't. That's the problem. We have judges who think they can just make laws for people beyond the parties of the suit as if they make law. They don't. That's the representative form of government that our legislators make our laws for us. And so he said, the candid citizen must confess that if the policy of the government upon vital questions affecting the whole people, that's what Chancellor Law was doing, affecting every registered voter in the state of Tennessee, even though she didn't have jurisdiction over them. And he says, if the policies are to be fixed, affecting the whole people, the instant they're made in ordinary litigation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. So see, what happened today is your representatives didn't understand that when a judge goes beyond her jurisdictional authority to make law for the whole people, and they are okay with that, and they are not jealous for their own powers to represent the people, and to represent the power the people gave them to make sure judges don't make law for all the people, then they have resigned your government into the hands of the judicial branch. Now, there are going to be a lot of lawyers and a lot of judges who are not going to like what I just said. But let me close with what Abraham Lincoln said. And if I get in trouble for being with Abraham Lincoln, who's also a lawyer and a president of the United States, then so be it. But here's how, his very next sentence. He said, nor is there in this view any assault upon the court or the judges. You see, it's not an assault. Because when judges think they can make law for the whole people, it is an assault upon the people. And the government is of and by and for the people. The judge's authority is prescribed by the people, and the power to make law for the whole people is given to their representatives, because this is a representative self-government. And if the leadership and the House Republican caucus don't have this issue reheard, then I'm afraid I can't say anything other than we have people who have decided it's okay to resign our government on important issues like ballot elections into the hands of the judicial branch.